battles on two fronts, not only to make money, but to keep those choices affirmatively available to everyone who wants them, and those choices have transformed America in a very real sense. How has this room and the people who sat in these chairs in prior Internexts changed the country? Well, I want to tell you something. There hasn't been one federal indictment for obscenity since Obama took office. The cases you've read about have all been cases that were brought and indicted under George W. Bush. One of the reasons, I suspect, I believe in my heart, why obscenity prosecutions have more or less stopped is because of what this room has done to transform American values in the intervening years. Three questions at the end. You understand that what is and is not legally obscene is in substantial part determined by what the local community accepts or tolerates. And frankly, not only your sites, but the tube sites have transformed the things that America grows up with. Things that were shocking when I was growing up are part of the landscape. The other thing that has dramatically changed the landscape is this whole gay marriage issue and gay rights to engage in consensual sodomy, Lawrence versus Texas. What kind of a jury would go into an obscenity case faced with the proposition that not only is consensual sodomy constitutionally protected, but in some states of the Union, it's enshrined and respected as marriage? That changes the way a jury looks at vaginal boy-girl sex, BDSM, the whole world of it. Look, in the history of the law, a marriage wasn't even valid until there was vaginal penetration. Even the Catholic Church will annul a marriage that hasn't been vaginally penetrated, that there's been no intercourse. What do you do in a climate where there's valid marriages, where there's no vagina to bring to the table? Okay? It's transforming the idea of what normal, respected sexuality is. And even a conservative member of the jury, he gets on the panel, he looks at what is enshrined and protected and respected in the law, he looks at what is normal fare on tube sites all over the country, and you think a prosecutor is going to have a decent chance of indicting him for boy-girl sex or even BDSM or anal or facials or anything. And the odds are remote. Look, I'm not saying don't worry about obscenity. Certain grotesque things may wind up going to trial, and they may wind up in convictions. It took 3 trials to get Ira Isaacs prosecuted, but by God, a federal jury in California, in Los Angeles of all places, convicted him of obscenity. And there will ultimately be a last person in the United States to go to jail for obscenity. It may happen. But the overall point is the battle has been substantially won, and won in large chance by the heroes in this room. One of the other, and what my prediction is, you're not going to see federal indictments for obscenity, certainly not many of them, if any at all, in 2014. Let's go on to 2257. Quick update to where it is. It was, judge dismissed everything. It went up to the Third Circuit. That court got very upset because 2257 interferes with individual privacy rights of people in their homes. The government was saying, oh no, we're not going to prosecute people in their homes, it's only about commercial stuff. And the government and the Third Circuit said, you're a bunch of liars, we don't believe you. You say that now, and as soon as we give our sanctioned seal of approval to this decision, you're going to go out and you potentially will break it. They ordered the case back to the trial judge in Philadelphia. He conducted the first trial in history that ever got to the merits of Section 2257. His result was more or less, in my view, a disgrace. He gave one concession to people. He said that if the records are kept in a private home, it is unconstitutional to demand an inspection without giving prior advance notice of the inspection. That's it. And now it's going back to the Third Circuit. Look, I think the major issue of this case was, and still is, other people disagree with me, that the major issue is the effect it has on ordinary, normal Americans with the cameras in their cell phones or their video, and I think that's where this statute has always been historically most vulnerable. Some lawyers have disagreed with me, saying, oh, Congress can just fix it up and then it'll only apply to commercial porn. I don't think they can constitutionally do that either. I think if this case is shrewdly advanced, 2257 is probably dead. Probably. But I can't give you a guarantee on that. I can't promise you that. And if you have half a sense of what's smart and right, you will vigorously and punctiliously comply with 2257 to the dot, because my prediction is not certified and written in stone. It may be wrong. Ultimately, people may go to jail, and guess what? It's a 7-year federal statute of limitations on this. So comply rigorously. Now, the other side of the coin, and where I think the real dangers are in 2014 is this. It's the disputes between persons. Now, Clyde was talking about this, and Michael has spoken about this, and I can't emphasize strongly enough, representing real-world clients, where I see this going. So far, there hasn't been much where models have successfully gone after producers of content. And I'm not going to talk a lot about it publicly, because the last thing I want to do is hurt anybody in this industry, especially the producers and the webmasters who are my clients and for whom I depend for a livelihood. But I think there's a great deal of vulnerability. I think the day is coming, and I've dealt for years with these models coming and asking for takedowns, and this and that and the other thing, and these complaints, and they're vicious. Somebody out there has actually produced a mobile phone 2257 ad. Think about what you give up when the only record of your dealings is a digital swipe of your finger on a screen. When people want their content down, when girls want their content down, they come back and they say, I was coerced, I was drunk, I was under the effects of drugs, I was underage. It's a whole laundry list. But the most powerful weapon in my arsenal over the years, dealing with many of these, is the fact that I have a paper and pen signature and much abundant literature about their dress size and what their phone numbers are, and what their address is. And if a girl says to me, I was under the influence of drugs or I was drunk, I can take that to a graphical analyst, and I've got examples of her fine motor skill that'll disprove any proposition that she's drunk. And look, if you want to use a mobile app, you go right ahead. But why would you throw all that valuable stuff out that protects you against these models? And that's the only case I'm going to go into detail on. But you have to, there has been, in my opinion, an abysmal lack of understanding about workers' compensation issues, unemployment issues, and many other things. And if you consult your state statutes, some of you may be shocked about the situation.
I have a feeling Michael wants to follow up.
Yeah, pardon me.
I just want to address something really quick. Not so much from a standpoint of taking content down, but if you do not pay a model in California, are you ready for this? We have penalties in California under employment law that says that model is entitled to her day rate for up to 30 days as a penalty. If you do not pay a model or the check bounces, you will end up paying that model $30,000 in penalties on top of the $1,000 that you should have paid her as a rate. And that is a state Supreme Court case. You're not going to win that as a producer. Make sure you pay your models on time, and that means on the day of the shoot if you're producing in California. Do not try to do payroll. Payroll's going to end up costing you $14,000 in penalties. And these are easy cases. This is not a hard case to stick a producer with.
I really don't think it helps the industry to lay all of the many, and everything Michael says, no doubt is right. But I'm not sure it benefits the industry to make a public record of all of the vulnerabilities that content producers have. Trust me, they'll scare you once your eyes are open and once you're aware of them. And you've got to take proactive steps, and to take steps now before this cascade starts, which I fear is going to be one of the stories of 2014, to shore up your legal relationship with everybody around you, the people who work remotely for you, your programmers, everybody who does things for you, even when they work at home, your model releases, all of the relationships that you have with these people. Because I really see a hard rain falling this way. And I think it's going to be expensive, and I think there's a potential it'll hurt people. So get with your lawyer, and if you don't have a lawyer, don't go grabbing stuff off the internet, because it comes from people who are also too cheap to get good legal advice.
Just get it to GFY, you're fine. Okay, Clyde has a very quick follow-up to that, and then we're going to Corey for some really scary
stuff. The worst
stuff.
thing that can happen to you is if you produce child pornography. I don't have to tell you. I mean, a minimum 10 years in prison, federal, or if you get sued by a model who was underage when you shot, you say, I never shoot anybody underage. Well, of course you don't. You check their driver's license. There have been a handful over the years, dozen or so, models that have slipped through the cracks. It turned out they were underage, and guess what? Every single one of them had a driver's license issued by the Department of Motor Vehicles. Not forged, not changed. I think in the females that got through, I can't imagine what they might have done with the employee of the DMV that got a driver's license with the wrong age on it. But now, what happens if this happens to you? Somebody that looks 21 and has a fake DMV ID that says that they're 21 and they're really 17. What's your defense? What did you do to prevent a minor from being in your film? I did exactly what the federal government said I should do. 2257, that's how I kept minors out. I followed 2257 to the letter. I thought that was enough. And you know, they're gonna have a hell of a time saying it wasn't.
Yeah. We're going to go over it very, very quickly. I'm a plaintiff in that lawsuit, that 2257 lawsuit, and I testified as a witness at that trial. And I'm actually proud to say that my purpose for being at that trial was to testify about the inspections at home. Yes. So I think it's important for live cam people. There's a lot more people in this industry who work from their homes, that they're not going to get an unannounced knock on their door by an FBI agent, especially if they're not at home, maybe scaring their wife and kids half to death, which is what I testified about.
30 seconds. 30 seconds. Everything Clyde said is right. Now I want to supplement what he said. In some states, if the girl is underage and she has a valid ID, what appears to be a valid driver's license, she swears 25 ways under oath on camera that she's over 18. And you or someone else you're paying has sex with her. And those states, by the way, include Florida, and they include New York. In those states, lack of knowledge is no defense to statutory rape. You are guilty without any proof of mental knowledge or fault, just because you physically had sex with her and because she turned out to be 18, even with an abundance of paperwork that is in fact valid but improvidently granted by the government. This can be dangerous stuff. On my website, you can read about it in the article on 2257. I give the names and tell you true stories of the women involved.
Yeah, I wouldn't be surprised if everyone in this audience in the industry has 2257 fatigue. I know that I do. It's been around for fucking ever. But you know, there isn't a website that I'm writing about or interested in that where I don't go check the 2257. I do it habitually, every single one. And over the last year or two, it's a little depressing. Okay, we're going to go to you, Corey, and Corey is going to talk about recent FTC inspections.
Well, hi everyone. Everybody still awake? All right, good.
Walk the floor, Corey. Two stoves, monkey trial.
All right. Everything these gentlemen up here have been talking about today are very important information. A lot of really good stuff that you guys should be taking home and applying to your everyday lives and your everyday businesses. I'm going to be talking today about something that I actually did a separate presentation on yesterday morning. I went a little bit more in depth into it yesterday, but after our presentation, since I've been at the show, something very interesting has happened. I do a lot of these shows every year, and I always love the feedback because I always want to know how we can do better as presenters to give you guys the information that you want. And the interesting thing is that yesterday I did a presentation that Clyde actually and JD were kind enough to sit in on, involving some very large problems that are going on. And since I did that presentation, evidently there are some dating sites that aren't very happy with what we presented yesterday. So I'm going to go ahead and talk about it again, because that's kind of what I do. And frankly, I don't really care that they're upset. It's their own problem because they created this mess. So I'm going to tell you guys what the mess is. Lately, there has been an increase. Let me take it a step back. There is a branch of the government that's actually, it's a commission. It's called the Federal Trade Commission. Okay? Now, here's what's been going on. The FTC has the ability, and they're authorized by the executive branch of the United States government to pursue what's known as unfair and deceptive practices. About a year ago or so, the FTC actually very publicly warned dating sites and warned all of those individuals that are involved in dating sites that we are not happy with what you're doing. We're not happy with virtual cupids. We're not happy with fake profiles. We're not happy with the fact that you advertise 25 million members. 3 of those members are actual individuals. 5.79 million of them are bots or what have you. The FTC sent that out. They let us know. They told the industry, fix what you're doing. We didn't. So what's been going on in the past couple months that the industry doesn't want to talk about, that isn't plastered on the face of the boards and the magazines, and that is that there are 3 that I am involved in presently that FTC has sent out what are called civil investigative demand letters. These are known as CIDs. Now, what these letters are in essence, it's a letter to you saying, guess what, you're on our hit list now. We want to know everything about your business. We want to know everything about what you're doing. We want your stats. We want your revenues. We want to know who your shareholders are. And we want all that because we're going to make you pay because we're tired of all the consumer complaints. These are going on not yesterday, not in 6 months from now. These are going on now. Dating sites are directly in harm's way now. Affiliates of dating sites are in harm's way now. If you're whitelisting dating sites, it's the same thing. The FTC has a very broad authority. They can go pretty much as deep as they want into your personal affairs if they decide that you're one of their targets. And once you